This change is a profound shift in how South African law recognizes parenthood. We have now one single category, parental leave, that applies equally to all qualifying parents. In the landmark judgment handed down by the Constitutional Court on 3 October 2025, South Africa's parental leave laws were changed fundamentally. The court ultimately confirmed the 2023 High Court decision declaring certain sections of the Basic Conditions of Employment Act and the Unemployment Insurance Act unconstitutional, specifically those dealing with maternity, parental, adoption and commissioning leave. The court has given Parliament 36 months to amend the law, but importantly, it has handed down an interim order which has immediate effect as of 3 October 2025. Under this interim order, the old distinction between maternity and paternity leave is now gone. We have now one single category, parental leave, that applies equally to all qualifying parents. So what does this mean in practice? Parents now share a combined total of 4 months and 10 days of parental leave. How they choose to divide their time is really up to them. They can take it concurrently, consecutively, or even a mix of the two. If they cannot agree, then the leave must be split as equally as possible. Alternatively, if only one parent is employed, for example, if the other parent is a stay-at-home parent or a single parent, then that person gets the full 4 months and 10 days of leave. The new entitlement also extends to parents in surrogacy arrangements and parents who adopt a child under the age of 2. Importantly, however, while the new interim parental leave entitlement is already in effect, an interim order in respect of the UIF benefits was not handed down by the Constitutional Court. So in other words, even though both parents can now take the full leave benefits of 4 months and 10 days, the UIF only pays out up to 10 consecutive days for the father as the fall. So given these changes, employers should act quickly in order to stay compliant. At a minimum, we recommend that employers review and amend all employment contracts and leave policies to align with the Constitutional Court's interim order, as well as engage trade unions where collective agreements cover parental leave to ensure they reflect the new legal position. Another important factor to consider is where a company already offers enhanced maternity or paternity benefits, those must now be extended equally to all parents.